of the Supreme Court of Ohio. The Honorable Supreme Court of Ohio is now in open session pursuant to adjournment.
Good morning, ladies and gentlemen. Welcome. Our first case this morning is 2019-531, Defender Security Company, DBA Defender Direct versus Joseph W. TESTA, Tax Commissioner of Ohio. For the appellant, Mr. Fry.
Thank you, Your Honor. Good morning. May it please the court. My name is Rich Fry, and I represent the appellant Defender Security Company. I would like to reserve 4 minutes for rebuttal. When taxing interstate business activities, states may choose to tax either the origin or destination of these activities. For Ohio, the General Assembly chose destination-based sourcing for the commercial activity tax. This focuses on the purchaser's location, not the location where the seller's activities occur. Simply put, the issue in this case is where does ADT receive the benefit of the alarm services contracts it acquires from Defender Direct? According to the plain language of the statute, the physical location where ADT receives and uses this intangible asset is paramount to determining where the benefit is received. In this case, the 10th District adopted... Excuse me?
Yeah, Mr. Fry, is it irrelevant where the homeowner is?
Yes, because that's not the purchaser in this case. The purchaser is ADT. So you can't look through to the homeowner's benefit. The tax commissioner has focused on the protection of people and property in Ohio. However, that is not the benefit that ADT receives from Defender Direct. In fact, ADT, the purchaser, has no people or property in Ohio to protect. And that is part of the flawed reasoning that the tax commissioner has used in this case, confusing the two distinct transactions. One is ADT's purchase of the contract from Defender Direct, and second, a totally separate transaction is the consumer's purchase of the underlying services from ADT. Only Defender's sale of the intangible assets is relevant in this case. We're not talking about gross receipts from providing monitoring services to Ohio customers. Defender earns these gross receipts from the sale of intangible assets to ADT, which ADT receives at its headquarters in Colorado, and then benefits from by providing the services under that contract from its 6 monitoring centers, which are also outside of Ohio. Defender Direct also sells and installs security equipment. And of course, we would contend and concede that Defender is subject to commercial activity tax from its gross receipts from the sale of security equipment. And ADT is subject to commercial activity tax on its gross receipts from the sale of monitoring services to Ohioans. In both of those cases, the purchaser is physically located in Ohio. But that's not the case with respect to the gross receipts at issue in this case. The gross receipts are not from protecting people and property in Ohio. Instead, they are from the sale of an intangible asset, which provides ADT with the benefit of providing services, which it does from outside of Ohio, in exchange for a monthly fee. The appellant's first assignment of error is that the 10th District applied the incorrect standard of review when it afforded the tax commissioner's determination of a legal question, afforded it due deference. Although the 10th District recited the correct de novo standard of review, the opinion reflects a substantial deference to the tax commissioner's determination of a legal question. To support this level of deference, the 10th District relies upon cases where an administrative agency made a factual determination or applied its own administrative rule. Those situations are not at issue in this case. This court has repeatedly held that the tax commissioner is not entitled to deference on its determination of legal questions. And this makes sense because the tax commissioner is an administrator. It is not the arbiter of legal questions. That is why independent oversight is provided in Ohio by the Board of Tax Appeals and the courts. Appellant's second assignment of error is that the 10th District adopted the incorrect application of the statute. the citing statute. As I mentioned, the correct standard of review is de novo, because we have a case where there's undisputed facts applied to a statute. The undisputed facts are that the receipts are derived from an intangible asset sold to ADT, that is the alarm services contracts. Second, ADT has no physical locations in Ohio. ADT receives the alarm services contracts at its headquarters in Colorado. Then ADT benefits from those contracts by providing the monitoring services from its non-Ohio locations. The citing statute provides that gross receipts are cited to where the benefit is received. Admittedly, it's very difficult to determine where the benefit of an intangible asset is received, because by their nature, there isn't a geographic location associated with those assets. That is why the statute and Professor Pomp, an expert in state and local taxation, has directed us to rely upon the purchaser's physical location where that asset is used and received. The CAT utilizes a whole set of rules in the citing statute based upon the customer's location. When tangible personal property is purchased, it's where the purchaser receives that product, not where the end consumer receives that product. When a service or intangible asset is at issue, it's where the purchaser receives the benefit of that. This is destination-based sourcing. The focus must be on the purchaser and its physical locations. But now that we have a Colorado purchaser in ADT, the tax commissioner has attempted to come up with a different rule. The tax commissioner based its conclusion citing the gross receipts to Ohio based upon two erroneous conclusions. First, it applied origin-based sourcing based upon the fact that Defender Direct originated the contracts in Ohio. Secondly, it failed to distinguish between the two separate transactions in this case. That is the sale of the intangible asset to ADT as opposed to the sale of monitoring services to the end consumer. ADT is the purchaser in this case, not the end consumer. The relevant benefit that ADT acquires from Defender Direct is not the protection of persons and property in Ohio. In fact, ADT has no people or property in Ohio to protect. Instead, the tax commissioner used a look-through approach to associate the benefit received by the consumer from the monitoring services to ADT's benefit from the intangible assets. This is incorrect. The tax commissioner did this by using a but-for test. Essentially, without Ohio, Defender Direct would not have been able to originate the alarm services contracts. While this is true, factually, it's irrelevant for destination-based sourcing for the commercial activity tax. Any service provider that performs a service in Ohio, such as the accountant or attorney examples in the Ohio Administrative Code, could not be performed without Ohio. And the service provider in those examples certainly benefits from Ohio's government services and protections. But Ohio chose not to tax the services and intangible assets based upon where the seller performed the activity. Instead, it is based upon where the purchaser is located. Think about the result of a without Ohio test. Any type of revenue, directly or indirectly received from Ohio, would be subject to tax. This would include revenue from services or assets that originate here, are destined here, or travel through Ohio through its roads or telecommunication services. We need to step back and arrive at a more definitive and clear test. Consistent with the citing statute and Professor Pomp's guidance, that test should be determined based upon the purchaser's physical locations. Finally, appellant's third assignment of error is that the tax commissioner's application of the citing statute violates the U.S. Constitution, the Commerce Clause under the U.S. Constitution, specifically the fair apportionment prong. Fair apportionment protects taxpayers from multiple states taxing the same revenue or income. It requires internal consistency, which assumes that a tax identical to the one in question is imposed by every state. If under this test, that revenue would not be subject, the revenue in interstate commerce would not be subject to any additional burdens that intrastate commerce would not also bear, then the tax is constitutional. However, in this case, the violation is caused by the tax commissioner's inconsistent application of the citing statute. And specifically, it ignores the purchaser's physical location. If every state applied the citing statute as the tax commissioner has done, using a without Ohio or but for Ohio test, the revenue at issue would not just be subject to double taxation, but at least 6 states could attempt to tax this revenue. In fact, if Colorado imposed the commercial activity tax in the same manner, it should also be taxing this gross receipts under the tax commissioner's test, based upon the same principles that the tax commissioner uses in its administrative rule with respect to agency and advertising services, as well as the principle in USC consulting. And that principle is that the purchaser's headquarters is located in Colorado. And if there are no questions, I would like to reserve the rest of my time for rebuttal.
Thank you. Mr. Hendershot.
Chief Justice O'Connor, and may it please the court. This case, I want to begin by saying, has come down to being kind of a shadow of its former self. We've heard very little about the constitutional claim and very little about the deference claim. That leaves just a straightforward statutory interpretation claim. And what I hear my friends saying on the other side about that question is that the difference between market-based and performance-based sourcing answers the question. Well, it isn't quite as simple as that. And one of the cases that defender cites in its brief, the Minnesota Supreme Court's decision in Lutheran Brotherhood, makes exactly that point, that picking between these two dominant models of state taxation for things like services and intangibles isn't going to answer the question in all cases. You have to look a little deeper. If you look at the regulations that Defender itself has pointed you to, the regulations 5703-29-17, you can see examples in there of sometimes something is going to be sourced at a corporate headquarters. Say that you're redecorating the corporate headquarters or training the management, like in Lutheran Brotherhood. That may be a benefit received in the place of the corporate headquarters. But other things, and these following examples I'm going to give, are in subparagraphs C 32, 41, and 51, legal services, concert promotion services, warehouse logisticsing services. All of these things are benefits to an entity that may be headquartered elsewhere, but they are benefits that take place where those services are performed. And the intangible here, the contract intangible, which was a right that Defender created and then sold to ADT, is something that benefits ADT in Ohio because it is a contract right that gives ADT the right to charge Ohio consumers to monitor real property in Ohio. So not only the plain meaning of the
Counsel, if their services for monitoring were not part of the deal, would there be anything, and there was a sale, but for some reason the services didn't follow through, there was an impediment or something, would we be talking about taxation of the Colorado entity?
Well, the taxation here is of Defender, an Indiana entity, and if there were no if the contract fell through, which happens in about 5 to 6% of the cases where ADT does not accept the sale of the contract rights, then in that case, Defender retains the services, retains the contract, and then it's just a provision of services to an Ohio homeowner. Defender mentions at page 21 and footnote 1 of its brief that of course is taxable. But that just shows that what they sell. It's
taxable to whom?
So in that situation where Defender retains the servicing, then there's nothing, they haven't sold a contract right in that case. They'd be providing service directly to the homeowner. That would be taxable to Defender for selling a home monitoring service about Ohio real property. And that just shows that when they sell this contract right to ADT, what they're selling is something that benefits ADT in Ohio. It's not just the plain meaning of selling an Ohio contract right. The canon of consistent usage shows this as well. If you look a few subparagraphs up in the statute we're talking about, we're looking at subparagraph I. Well, subparagraph F deals with a different class of intangibles, and those are intellectual property intangibles. And those are plainly taxed where the intangible is used. And so the canon of consistent usage of the word use, used in the same sense in both of these provisions, shows that this intangible that has value to ADT in Ohio should be treated in the same way as a sale of a copyright or a trademark or something of that nature.
Counselor, how is it valuable to ADT in Ohio if ADT is in Colorado?
Well, in the same way of, let me turn back to those examples, and the legal services one is that one defender itself points to at page 15 of its brief. In the examples here, talk about a Michigan corporation or a Tennessee corporation using legal services in Ohio to resolve an Ohio tort or an Ohio matter before the Board of Tax Appeals. In both cases, that is value in Ohio because it's resolving an Ohio matter. This is value in Ohio because it is giving ADT the right to charge Ohio homeowners for the monitoring of their Ohio property.
But in the example that you give, aren't the attorneys in Ohio reaping the financial benefit?
Well, they wouldn't have to be. In those examples, the firm could certainly be a DC firm that was performing the work in Ohio, or the other two examples, like the warehouse logistics thing or the concert promotion, things that happen on the ground in Ohio. And another way to think about this is take it away from the intangibles for a moment and think about it as a service analogy. This is sort of a service the defender was providing that's analogous to a contract intangible. What it's doing is it is performing a service for ADT on the ground in Ohio by being in the homeowners' houses and doing the legwork to create these contract rights.
But isn't the installation taxed? Isn't that taxed when defender does its work? I mean, when defender does its work in the client's house, isn't that installation, that cost taxed?
It is, but there are two things going on there, Your Honor. There's not just installation of the physical equipment that monitors the property. There's also creating the contract that then defender will turn around and sell to ADT. So that on-the-ground legwork is something that is a benefit to ADT on the ground in Ohio, like on-the-ground legal services, on-the-ground concert promotion services. And let me point you to some out-of-state cases that make this point, starting with the South Carolina Supreme Court, but then also the Iowa Supreme Court. The highest courts of Maryland and Massachusetts have looked at this question in the matter of intellectual property, where two out-of-state companies exchanged intellectual property in the form of a trademark, and the court in all of those cases said, well, that exchange is something that created value for the buyer and the seller in the state where there was permission to use it, even though the headquarters of both of the relevant companies in the transaction were not in South Carolina and Iowa and so forth in those instances. So, Your Honors, sorry, I saw your bar light up, Justice.
No, that's all right. I just said thank you. Go ahead.
Okay. So, Your Honors, I do want to touch on both the constitutional question and the administrative deference point, because as we see it, those matters aren't really even on the table anymore. Defender said initially in its jurisdictional brief and its opening brief, it would show a violation of the federal constitution's dormant commerce clause. If you look at pages 13 to 15 of its reply, it says, for example, on page 13, there's no doubt that Ohio could tax these receipts. Instead, it is saying, well, no, what we mean is the violation is somehow taxpayer to taxpayer variability. Well, that's not a dormant commerce clause problem. That might be something like equal protection, but defender has pointed to no case that shows that comparing taxpayer treatment within a state is something that triggers the dormant commerce clause at all. And it hasn't pointed to any case that would show taxpayer to taxpayer variability. You heard my friend mention the USC consulting case, which was just like the Lutheran Brotherhood case, that was a service, some kind of consulting service that was delivered at the corporate headquarters, valuable because it was training those at the corporate headquarters. It was unlike the on-the-ground service that defender is performing here to create contract rights, or like the analogy of selling an intellectual property intangible, or here a contract intangible. And if you want to still consider, despite defender statements in the reply, well, what about consistency? The US Supreme Court's test of hypothetically consider whether other states would do what Ohio does. Well, let's look at what Colorado does. Colorado's own statute and regulations, and these are found at 39-22-303.6 in the Colorado statutes, and then their regulations are numbered in the same way. Colorado says if you have an intangible right that gives you the permission or the ability to operate in some place that's geographically linked. You buy an intellectual property right, a contract right to perform in the state, and that is taxed in that state. So really there is no concern here of overlapping taxation. As we pointed out at page 21 of our brief, even if Colorado had some different system, some overlap in taxation doesn't actually violate the Dormant Commerce Clause. The U.S. Supreme Court has said this in Goldberg versus Sweet, in Oklahoma versus Jefferson Lines, but our reading of the reply brief shows that Defender really is pushing something that looks more like a uniformity or equal protection argument without pointing to any similarly situated taxpayers. In fact, in cases that deal with intangibles that are in, these are not in the briefs, but they're in the tax processing right now, there is consistent treatment of intangibles like this, whether intellectual property or contract rights. Now, I want to talk about deference for a moment, because that is one of the main propositions of law here, and one of the reasons the Defender said justified this court's jurisdiction. 3 quick points to make about deference. Number one, what Defender said it didn't get was de novo review, but paragraphs 22 and 30 of the 10th District show that it's consistently saying we're applying de novo review to this question. Number two, Defender says, but there are these citations to administrative deference cases in the 10th District's opinion. That's true, but for 2 reasons that's irrelevant, because what those cases were used for in the 10th District opinion on our reading was an administrative interpretation of an administrative regulation. Number one, Defender says that kind of deference is fine. Number two, it's not an issue in this case anymore because that related to the commissioner's interpretation of his own regulation about agency services. Well, Defender, I've not heard a word about them arguing that they're still trying to claim they're an agent of ADT. That was a factual finding. And if you look at the contract at the statutory transcript, page 127, you'll see that the contract between ADT and Defender says they act as independent contractors and can't bind one another. So plainly not an agent. And that's a factual finding below. There's certainly no clear error on that point.
Well, why would we think that that has to do with the agency finding? It's not in that section of the opinion. It's right before the Court of Appeals' conclusion. What is there that would make us think that?
Well, it's right after they quote, this is the 10th District, quotes the part of the BTA opinion dealing with the argument under the subparagraph C4 of the regulation dealing with agency. But even if you think the 10th District is referring to something else, say that you think they're referring to something like Chevron deference or what you might call Lang deference in this court, that's also not on the table for this reason, really 2. Number one, the commissioner is not saying defer to his interpretation of the statute. And number 2, it wouldn't make a lot of sense to advance that argument because there's no written interpretation of the statute by the tax commissioner or the Department of Taxation to defer to. The written regulations deal with services, not contract intangibles. And really there'd be kind of a bit of irony in Defender saying, well, don't have any kind of deference. Don't look at these regulations because Defender itself, page 15 of its opening brief, page 7 of its reply brief, encourages you to look at the regulations that are written, at least in terms of their power to persuade. And so whatever way you look at deference, it's not an issue that's really in this case because the commissioner is not advancing a Chevron deference argument. The deference of an entity to its own regulations is not an issue because Defender says it's fine, and it's not really an issue because the agency argument is gone. One final thing, Your Honor, as to why the deference and the constitutional arguments having changed that points towards perhaps dismissing this case as improvidently granted. And that is there's an evidentiary hurdle to even reaching the statutory question. All of the information about the tax that Defender paid here is on 2 pages of the statutory transcript, pages 189 and 190. But for a couple of reasons, you should lack some confidence in those numbers. Number one, Defender originally requested a 400% refund for all of the quarters of 2010. And to its credit, it withdrew that request, but it shows that the numbers had some problems with them. Number 2, there are no business records that support disaggregating the different streams of Defender's income. That's important here because Defender admits to look at page 21 of its brief, that it owes tax on some of what it received. And the third reason to lack confidence in these numbers is a defender's own witness, this is at page 82 of the BTA transcript, said she couldn't testify the defender had paid in initially everything that it was now claiming for a refund. So if it underpaid initially, perhaps it's not owed a refund now.
But doesn't that just counsel for us to remand to the tax if we agree with the appellant to just remand to the tax commissioner to calculate the appropriate refund?
Your Honors, we think it would certainly justify improving the case because it shows that the case is not, especially with the change in the constitutional and the deference points, that the case is not what it was when the court granted jurisdiction over it. And instead of using the judicial resources to answer that question and going back and having more evidence put in on this question because it was defender's burden to put that evidence in to begin with, that would make sense. But if you reach the statutory question, for purposes of plain meaning, parallel structure between subparagraphs F and I, and the persuasive out-of-state authority from South Carolina, Iowa, Massachusetts, and Maryland show that the Ohio statute says that the sale of an Ohio contract to monitor Ohio real property is something that can be taxed under the Ohio statute. Your Honors, we ask that you either improv or affirm the unanimous 10th District's decision. Thank you.
Counselor? Mr. Fry.
Thank you, Your Honor. I want to touch on obviously a couple points that my colleague made. First, in all of the examples that he's providing, there is some type of property or employees in Ohio that are creating some type of benefit for the purchaser. So when we're talking about warehousing or a contract service, you know, in the warehouse, there's the purchaser's inventory. For a contract, or a concert service, the purchaser is going to have employees in Ohio that are putting on those contracts. So there is a physical location in Ohio that the purchaser has, either through its employees or property. The same is true with respect to the IP cases that my colleague alluded to, the Jeffrey cases and the KFC case in Iowa. In both of those cases, they license the use of a trademark, the Toys R Us name or the KFC Kentucky Fried Chicken name. The purchaser put the trademark on a physical building. They put it on their restaurants or their retail stores. So the purchaser had a physical location to which the IP was specifically used. In this case, there is no property that ADT has in Ohio that benefits from from the intangible asset. Instead, all of ADT's property is outside of Ohio. But the tax commissioner attempts to use this look-through approach, basically attributing the real property that's owned by the consumer to ADT, which is not appropriate in this case. The tax commissioner has already said you look to the direct purchaser in each and every transaction. That's in the Lexmark determination under the same citing statute.
Counsel, who owns the equipment that is installed in the homeowners' homes?
The end user or the consumer, not ADT. They purchased that from Defender Direct. And those gross receipts that Defender Direct realizes are subject to the commercial activity tax.
And if there was a failing of any of the equipment, who is responsible under the asset purchase agreement to replace or reconfigure?
Well, Defender Direct provides a 90-day warranty to the consumer, so it would fulfill that warranty. After that, it would be the consumer's responsibility to repair that property, and it could go through ADT or it could do it itself.
And if it goes through ADT, does ADT provide the replacement equipment or does Defender?
I believe that ADT would provide the equipment, although they could subcontract the installation to Defender or one of its other authorized dealers.
Does that affect the analysis at all?
It should not, because that occurs first of all, in a minority of the situations, but that occurs after the transaction's already been complete. Here, we have to focus on the sale of the alarm services contracts. We can't, if something happens a year or two down the road where the security equipment breaks, that would be irrelevant to the sale of the alarm services contracts. Additionally, I think the problem here is we have to identify the benefit that ADT receives. ADT receives the right to perform a service. It exercises this right under the alarm services contracts from its physical locations outside of Ohio. Additionally, I would like to mention with respect to the evidentiary issue, Justice DeWine did touch on that if you do decide that it was not properly proven, that it should be remanded. But keep in mind, the CAT return is very simple. It's one page, essentially a postcard, okay? So the business records to determine the refund claim are not all that extensive. So, and we provided those records. They were looked at by the tax commissioner's agent. In the final determination, it came to the conclusion that $77,418 of tax was paid on gross receipts from the sale of alarm services contracts. Kathy George, Defender's Director of Accounting and Controller, confirmed that this amount was correct. Therefore, I would respectfully request that this court reverse the 10th District's opinion and order the tax commissioner to grant Defender Direct's refund claim for $77,418 of commercial activity tax plus interest. Thank you very much.
Thank you. Thank you, gentlemen. We'll take the matter under advisement. You'll be notified of our decision. All right. Our second case this morning is 2019-646, the State of Ohio versus Michael Hudson. For the appellant, Mr. Hardwick. Mr. Hardwick?
Yes, Your Honor. May it please the court, like Chief Justice O'Connor, I'd like to reserve 3 minutes for rebuttal. The 10th District turned this court's 3-part test into a 2-part test, and that's something lower courts are not allowed to do. In State versus Grimes, this court set gave trial courts clear guidance and crystallized nearly 20 years of precedent to explain what exactly has to be in a judgment entry of sentence for that entry to properly give the executive branch authority to enforce post-release control. And one of those 3 prongs was that the consequences, some form of a reference to the consequences had to be in the judgment entry. Now the 10th District acknowledged that that's what this case, in paragraph 14, that that's what this court required. But the very next sentence started with the word however. And after they followed that, however, with a holding that based on their own prior case law, that they weren't going to enforce that 3rd prong. Now, the state argues that that this was somehow new, that this case law was somehow new, but it wasn't. This is based on 20 years of precedent, going back to Woods v. Telb, where this court specifically held that the consequences for violating post-release control were part of the punishment of post-release control, and survived the separation of powers challenge only because a judge has to impose post-release control. The executive branch just can't do it on its own. And that is based on precedent that goes back to the 19th century, where this court has held that it's the job of the judiciary to impose a punishment, not the executive branch. Now, this court in Phipps and my friends in the solicitor's office have been have accurately told this court and explained that lower courts must follow this court's precedent. They aren't allowed to dissent. I'd also like to talk about the so-called retroactivity issue in this case, because this court has never in its history of post-release control gone back and re-examined what its own precedent was at the time a judgment entry was issued. And further, the state's argument is completely unworkable and is an untenable middle ground because instead of having one standard from this court for the executive branch to look at, we would have 13 different standards. We'd have to look at, well, what was the law in Cuyahoga County versus the 4th District back in 2006 versus 2008 versus 2012. So under the state's theory, the executive branch would have to go through the case law of this court as well as 12 different appellate courts in order to decide whether any given entry properly authorized the executive branch to impose post-release control. And this court has also repeatedly held that without that proper imposition, that the executive branch is, quote, without authority or, quote unquote, powerless to enforce the sanction. I believe, Your Honor, those were the most important points I had for this court.
Mr. Hart, what about the state's, the AMICUS's argument that we could just simplify this whole thing and get rid of the modern voidness doctrine altogether? Isn't that something that would benefit criminal defendants?
It would benefit criminal defendants, and it would eliminate the Holdcroft issue in this case, because then the state would lose, not because it sat on its hands for more than 10 years without trying to fix this. The state would lose because it failed to appeal the initial judgment entry. And I think part of the state's confusion over the voidness doctrine is that the state, and both the state and its amicus, skip an analytical step. They go straight from what does the entry say to is it void? And there's a middle step. That middle step is you have to decide whether that entry properly authorizes the executive to enforce post-release control. Because if that entry doesn't, then we have the question of when can the executive fix it? And the voidness doctrine gives the executive branch additional time to fix the error that was in the defendant's favor. And I've also heard numerous times where this court has held, where I've heard judges or prosecutors argue, well, the defendant failed to appeal this. Well, no, it's not my client's job to appeal a sentence saying, Your Honor, appeals court, please punish me more than the trial court did. That's essentially what the state and its amicus say that my client should have done. If there's an error in the defendant's favor, it's the state's failure to file a timely appeal. The main reason I'm sticking with the current case law is it's clear this court, despite there have been problems with disobedience in the lower courts, but there isn't real confusion. The voidness doctrine, the state has failed to its parade of horribles, quite frankly, isn't all that horrible. And it has, as Justice Dwight pointed out, helped the state when trial courts have failed to impose state mandatory punishments like driver's license suspensions or fines or restitution. And it also can affect the defendant. You know, without the voidness doctrine, it's possible that someone who is illegally sentenced to life without parole would have to die in prison, even though the statute didn't allow the judge to impose that sanction. If the attorney, if res judicata or the failure to file a timely appeal stepped in and caused that. It is not a doctrine that has created confusion. It has created some resistance from lower courts. And there's a distinction between resistance and confusion. And what we have is, if this court decides to depart from its 20 years of precedent on this issue, it will only encourage lower courts to further resist this court's opinions. It'll undermine this court's status. That's why we have stare decisis. It's so because this court, if this court sticks with its opinions, they have greater force. And I note that after State versus Comer was issued, then Justice O'Connor wasn't on the bench, but she issued a concurring opinion saying that she would follow it based solely on stare decisis, because a 4-3 majority of this court had decided that, and it was the opinion that should be continued to be followed. The state also makes some arguments under Galatas trying to ask this court to overturn its precedent, but first of all, that has never been applied in a criminal context in a majority opinion. And second of all, this is a very different situation from Galatas. Galatas involved a decision, the Scott Ponzer decision, which was a single shock to the system that radically changed insurance contracts all over the state immediately in an unexpected way. By contrast, post-release control and the doctrines around it have been a developing doctrine over the past 20 years. And yes, in State versus Grimes, this court was the first time this court specifically said that by itself, one of these three things makes post-release control invalid. But a number of cases leading up to that, including Sarkozy and Singleton, have addressed the failure to properly impose consequences as a reason why the underlying sentence did not properly impose post-release control. And what the state seems to be arguing is that this court's decisions should be limited to their facts, and we should look at each individual case. We need to have a judgment entry that's directly on point to the judgment entry in this case, and that's not what this court does. This court decides issues of law. Under the state's theory, this court is just another error correction court, looking case by case to see, well, what does this entry does? And lower courts are only bound by this court's decisions in factually identical cases. The general holdings of this court are irrelevant.
Any reason that we should have a system where a technical sentencing error can be raised at any time, but a constitutional error, principles of res judicata apply? Does that make any sense to you?
Well, this is a constitutional level error because it involves the separation of powers, and it involves the question of did this entry do what the General Assembly required a judge to do, looking at its four corners. And I guess if this court wants to eliminate the voice,
the General Assembly has been pretty clear that even if the judge doesn't do what it's supposed to do, that the executive can still impose post-release control.
And if that became the law, then post-release control would become unenforceable for everyone because it's that judicial imposition that saved post-release control from the fate of bad time. And what happened with the House bill that led to 299-191 and related changes is, before that, this court drew a line of separation of powers and said, only courts can do this. And the General Assembly said, well, we disagree with this court's constitutional ruling about the separation of powers. We think that criminal punishments can be imposed without a judge. And if this court accepted what that part of the General Assembly, that part of post-release control rules from the General Assembly, post-release control would collapse and would apply to no one, or at a minimum, we'd have to go back to Woods v. Taube and start the last 20 years of litigation all over again because we now have a major separation of powers problem. In fact, this court would basically have to overrule Woods v. Taube. That's 20 years of precedent. Woods v. Taube has never been called into question by this court. It is firmly rooted in this court's decision law. This court should not overrule Woods v. Taube by giving the General Assembly authority to overrule this court's constitutional decisions. And yes, the General Assembly gets to define punishment, but this court draws the constitutional lines, not the General Assembly. Unless there are any other questions, I'd like to reserve the remainder of my time for rebuttal.
Thank you. Counsel?
Thank you, Madam Chief Justice, and may it please the court. I'll be sharing my time with Mr. Keller from the Attorney General's office. And I stand on my brief on all the arguments, particularly with regard to retroactivity, and also with regard to the state's argument that this entry actually does comply with Grimes by incorporating the notice under 2929.19B3E. But beyond that, I want to make 3 points this morning. The first point is that the general tenor of the defense's briefing, particularly the reply brief, and as continued in the argument this morning, is that any error in imposing PRC makes PRC void and unenforceable. And that's just not true. As I explained in my brief, the absence of consequences language in a sentencing entry does not result in void PRC under the standards under Fisher. And it also does not result in unenforceable PRC under the standards set forth in Watkins versus Collins. And to this point, I think this is a large reason why PRC cases just won't go away. It's because PRC has truly become a game where defendants argue that any error in imposing PRC results in immunity if it's not corrected in time. And I think this would be a perfect case for this court to either do away with the void sentence doctrine altogether, or at the very least, return to first principles and reiterate and clarify that under Fisher and Watkins, only a certain narrow category of errors would make PRC either void or unenforceable. The defense says that the 10th district changed Grimes' 3-part test into a 2-part test. I disagree with that. What the 10th district did was simply recognize that the entry, even if it did lack consequences language, again, we dispute that, but even if it did, it was an error, but it was not the type of error that would make PRC unenforceable under Watkins versus Collins.
Counselor, you mentioned that you would return to first principles and would say this is a narrow line of mistakes that would be found to be void. So in your view, what are those narrow principles?
Well, Fisher talks about how a void sentence is one that is facially invalid because it is not authorized by statute. In other words, a void sentence would be one that omits a statutorily required sanction, or PRC being the most common example that we litigate, or it includes a sanction that is statutorily prohibited. And the consequences, the rule in Grimes that an entry has to include consequences language, I think it's notable that no statute requires a sentencing entry to include consequences language. Justice DeWine, you talked about this in your separate opinion in Grimes, where this is judge-made law. So just by that fact alone, the absence of consequences language cannot result in a void sentence. One issue that keeps being brought up in the case is whose job.
Counselor, can I interrupt you for a minute? Do you think the fact that this aspect is judge-made law then aligns with the statutorily mandated terms of PRC? Is our analysis the same, and whether it should be void or voidable?
No, if we're talking about a judge-made requirement, then a failure to comply with that requirement, by definition, cannot result in a void sentence. A void sentence is a very narrow type of error where the judge is basically creating a sentence that is not authorized by law. So, for example, I'm sorry, it looked like you had a question.
I was just going to say, so if a statutorily mandated term is left out, is the sentence or the imposition of PRC void?
If a statutorily mandated term is completely omitted, then yes, that would be a void sentence. That's what the issue was in Simpkins, which was where PRC was completely omitted. It's where the issue was in Beasley, where a mandatory prison term was omitted, but where a court simply fails to comply with a judge-made requirement, like to include consequences as an entry, by definition, it can't be a void sentence. And one point that keeps being brought up is whose job is it to appeal? In our view, I don't want to say when defendants should or should not appeal, but at least from a prosecutorial perspective, the state is aggrieved only when the error would make PRC or some other sanction unenforceable. The state is not aggrieved by every error that can be committed in the sentencing process. It's only when the error would make PRC unenforceable. And again, under Watkins versus Collins, not every error is going to result in unenforceable PRC. The defense talks about how the parole authority would have to create some sort of chart or matrix with 13 different categories. I reject that, because if the absence of consequences language does not result in a void or unenforceable sentence, then it's just not up to the parole board to keep track of consequences language at all. It's an issue that has to be raised by the defendant on direct appeal. I want to go to my second point, if I may, which is even if there is a void sentence here, we get to the point of, has the defendant already completed the prison term on the kidnapping count? Because it's the kidnapping count that we're really talking about PRC here. And the defense in the reply brief seems to agree that there is simply no law that dictates that the kidnapping prison term is served before the burglary prison term in this case. What the defense instead says is that the state forfeited this issue. And it's kind of odd that the appellant is arguing forfeiture against the appellee, but beyond that, the whole point of the void sentence doctrine is that your normal rules about waiver, forfeiture, invited error, res judicata, and all these other claim processing rules simply don't, they don't apply. Neither side, the defense nor the state, can waive or forfeit its way into a void sentence, and neither side can waive or forfeit away a trial court's authority to correct a void sentence. Simpkins talks about how a trial court is obligated to correct a void sentence, and that the state cannot bind the trial court into imposing a void sentence. And I think those rules would equally apply to correcting a void sentence. And the forfeiture argument simply doesn't fit when in the context of the void sentence doctrine. The last point I want to make is to emphasize that the completion of prison term deadline to correct PRC only applies when there is no PRC imposed at all. That was the case in Hernandez, and it was also the case in State versus Qualls. The reason for that rule is that once the defendant serves the journalized portion of the sentence, then he has an expectation of finality. But when PRC is properly imposed at the sentencing hearing, which everyone agrees in this case it was, and then the judge includes PRC in the sentencing entry, albeit erroneously or irregularly, then PRC is still enforceable under Watkins versus Collins, and the defendant has not completed the journalized portion of the sentence, and thus he has no expectation of finality to prevent what is essentially a simple nunc-pro-tunc entry, which is what the 10th District ordered in this case. Before I turn my time over to Mr. Keller, I just want to emphasize again that not every error is going to result in a void or unenforceable PRC. The court should end this game, and if it's not going to abolish the void sentence doctrine altogether, then at the very least, it should return to first principles and reiterate and clarify that only a certain narrow category of errors results in a void or unenforceable PRC. In the absence of consequences language, even if it is retroactive, again, we dispute that for all the reasons stated in the brief, but even if it is retroactive, the absence of consequences language simply does not result in a void or unenforceable PRC sanction. Thank you for your time, and with that, I will turn the balance of my time over to Mr. Keller.
Chief Justice O'Connor, and may it please the court, I hope to make 3 points here. First, quickly recap some of the reasons why the court should revisit the void sentence doctrine. Second, discuss why this case specifically might be a good opportunity to do so. And third, stress that overruling the doctrine would be neutral. It would apply to defendants and the state alike. This is another chance to end confusion. The void sentence doctrine has had over 15 years, 15 or 20, depending on how you're counting, to stabilize, and it's failed to. But I think Mr. Hudson is wrong to suggest that this is a Phipps-like case. This is not a case where the court just needs to be firm with lower courts about applying its precedent, because it's the precedent itself that is causing the problem. I remind the court of its recent decision in Straley. There, the court had to reverse because the lower court had actually been too respectful of the void sentence doctrine and its implications, even to the point of acknowledging that it reached an absurd outcome because of the doctrine. I think the bottom line is that every time this court takes on one issue in this area, others pop up. I think you see that in the fallout since Grimes, which has led to at least a three-way split among Ohio's appellate courts. I think you see that in upcoming cases on this court's docket, like Reed and Dowdy, where the void sentence doctrine has actually made its way into murder sentences now. I would encourage the court to look to the experience of Illinois, the Illinois Supreme Court in this area. After about 20 years of experimenting with a very similar void sentence rule, that court in 2015, in a case called Castleberry, decided to change course, and it did so very explicitly. If you look in the introduction of that case, and I'm quoting here, "The rule can no longer be considered valid. We therefore abolish the rule." And that's what we're asking the court to do in this area. This is an area that has just become unnecessarily complicated, and I agree with Mr. Hudson that this is not, and his counsel, that this is not a court of just error correction. We don't need another case-specific fix in this area. I think the court should get at the roots of the problem and abandon the doctrine.
Mr. Keller, let me ask you, you mentioned the Straley case, and I want to ask you what you think about that. If I'm recalling the facts correctly, the defendant was offered what was described by both parties, including the state, as a non-mandatory plea bargain. He was going to be serving non-mandatory sentences. He entered the plea agreement. The trial court judge sentenced him to a non-mandatory count of prison, when in actuality what he was convicted of should have been sentenced as a mandatory time. And then years later, he attempts to attack that. And this court, in a series of concurring opinions, said res judicata. Do you agree that on an error of that nature, the onus should have been on the state, not the defendant, to raise that sentencing error on direct appeal if we get rid of the voidable doctrine?
I certainly agree that returning to the traditional doctrine would be a neutral principle, and that in cases the state will have the onus to appeal, whereas in other cases it will be the defendant. I think in this specific case, the court should reject Mr. Hudson's attempt to flip the burden of appealing onto the state. At best, I think we're talking about a minor imperfection, not something, as Mr. Gilbert argued, that could render post-release control unenforceable. And I think Hudson is asking for a very strange rule here, in the sense that he wants the state to appeal even though the state doesn't think a mistake occurred, and certainly not one that they would have been appealing 11 years before Grimes. But I do agree with the premise of the question that there will be times when it will be on the state to appeal, and I think that the line will be who's actually harmed by the alleged mistake in the case. I do want to back up to why this case might be a good opportunity for the broad consideration of the doctrine. And I know this court probably remembers it has a very similar case before it in Harper. But if we're splitting hairs, I think this might be the slightly better vehicle, because Hudson does not allege mootness, so there's no question on that front. Also, he's represented by the Ohio Public Defender's Office in this case, which has taken the other side of the issue, so both sides are well represented. But perhaps most of all, I want to echo something Mr. Gilbert said. I think this case is a good example of the type of game playing that happens in this area, because there's no question about what the correct sentence is here. The first-degree felony kidnapping comes with 5 years mandatory post-release control. And there's also no question that Hudson remains in prison, so there's never been a chance for that post-release control to attach. But because of this court's prior case law, because of the void sentence doctrine, there's a two-step game going on here. First, you come up with some perceived error in how post-release control was imposed. Second, you argue that for some reason it's now too late to correct the doctrine. And while Hudson is applying this formula, he didn't invent it. You see it in cases, perhaps most notably Billiter, where a offender was able to turn a favorable mistake into a post-release control error that then unwound his escape conviction. To summarize, Your Honors, anyone looking from the outside at Ohio's void sentence doctrine would be confused why post-release control cases are taking up so much time, both before this court and Ohio lower courts. I think it's time to get at the roots of the underlying problem. We ask the court to overrule the doctrine. Thank you.
Counsel?
Thank you. Grimes, the decision from 2 or 3 years ago, is inconsistent with Watkins, the 2006 decision. This court in Ketterer correctly said that Watkins was based on a habeas standard that was much more deferential. This court and should not be applied out, and this court should not apply it outside of that context. The 10th District decided to rely on Watkins, a 2006 decision, even though Grimes set a clear 3-part test.
Are you going
I'd
to let
also like to address, and once if this court does anything to help this case, possibly putting a stake through the heart of Watkins could help the lower courts understand that the signed opinions that this court issued in Billeter and Sarkozy and Jordan and Grimes and Holcroft, which are all consistent with each other, should be the rule that the lower courts follow rather than the per curiam writ decision. But also when it comes to my friend in the Franklin County Prosecutor's Office kept saying that this was judge-made law. Well, drawing the line of separation of powers is a judge's job, and judge-made law, when it comes to the Constitution, is law, especially when it's this court setting the law and it's the lower court deciding that, well, that's just something the higher court said. This court should enforce its case, enforce nearly 20 years of its opinions dating back to Woods v. Teld. This court should decline the state's invitation to overturn Woods v. Teld by saying that post-release control can be enforced without a judicial mandate. And if this court should decline the state's request that would in effect undermine this court's authority.
Why wouldn't we wouldn't have to overturn Woods v. Teld. Why wouldn't we simply say that if a sentencing entry said 5 years of post-release control, or then a person is subject to 5 years of post-release control. If it's subject to 3 years of post-release control, then they're subject to 3 years of post-release control. If the court made a mistake, didn't explain the consequences language, didn't include that in the entry, it's the defendant's burden to appeal. If the defendant doesn't appeal, then that's the amount of post-release control they're subject to. If the judge makes a mistake and doesn't impose any post-release control term at all, it's the state's burden to appeal. If the state doesn't appeal, then that person cannot be placed on post-release control. Same with the driver's license suspension, some of the other things we've said voidness. It would make our law in this area just the same as if, for example, a defendant's Fourth Amendment rights had been violated, or some other right had been violated. Why wouldn't that be good for everybody? And why wouldn't that, you walk through 6-7 cases that's all trying to explain this. Why wouldn't this just make this a whole lot simpler?
Well, first of all, because it would overrule Grimes, which finally did crystallize the issue. And secondly, I guess at this court, I don't see how it would be the defendant's burden ever to appeal if the consequences language wouldn't be there. That would seem to me to still be the case.
Generally, that's if, for example, if the defendant has consecutive sentences, the judge doesn't make the sentencing findings, it's the defendant's burden to appeal that. Otherwise, they lose the chance to challenge that. Why wouldn't the same rule apply here?
Actually, I think that is a good analogy, but the analogy is, I think, that if the trial court didn't actually impose the sentences consecutively,
right? The trial court didn't impose the sentences consecutively, then if the state thought they should, the state would have to appeal. If the trial court imposed them consecutively, but did imperfectly, for example, by not making all the required findings, then it's on the defendant's burden to appeal. Why wouldn't the same rule apply here?
Well, I can see how that rule applied, but I think if it did apply, it would mean that the consequence that Mr. Hudson would not be subject to any consequences for violating, because that wasn't included by the judge and the state failed to appeal that. That would be the job of the state to appeal that if we were going to back out on that. And unless this court has any other questions, I ask this court to rule consistently with its 2 decades of signed opinions, and not to overrule Woods v. Teld, and not to go back to a world, and not to turn post-release control unconstitutional as a violation of separation of powers, and not to send it down the same hole that that bad time went into.
Mr. Hardwick, before you leave, let me ask one more question. Same question I asked, I think Mr. Gilbert earlier, is it, if in Grimes this court imposed the consequences language, how then is there a separation of powers issue?
Because what Grimes did, Grimes was building on the Woods v. Tell doctrine, and the question is, what words does the court need to put in the entry to constitutionally impose this sentence? Because
but these words are not in the post-release control statute at all, setting forth the consequences.
Yes, and the problem is that, yes, it is not in the statute, and that's why it comes back to, if the state wins that argument, then I'd argue we have a separation of powers issue, if that language doesn't need to be said. What this court's doctrine says is that as a matter of separation of powers, this is how specific a sentence needs to be in order to authorize the executive to enforce the sanction. If the language is not that specific, then constitutionally that line of separation of powers has been violated, and the executive doesn't have authority to enforce that sanction. Well, then we have the situation where the executive can't enforce a statutorily mandated sentence. It's because the constitutional deficiency means that the executive hasn't been empowered to enforce the sanction, hasn't gotten the constitutional authority to enforce the sanction. And when they don't have that constitutional authority to enforce the sanction, the sanction can't apply. The legislature has required it to be applied, and the defendant therefore that's where the separation of powers lines go. That's
okay,
why.
Thank you.
Thank you, Your Honors. Unless you have any other questions, thank you.
Chief, you're muted.
Okay, do we have all the attorneys that we need? Looks like what we do. Okay, our next case is 2019-655, the State of Ohio versus Kyle Patrick. For the appellant, we have Mr. Uhas.
Chief Justice O'Connor, and may it please the court, good morning. Chief Justice, if I may, I'd like to reserve 3 minutes of my time for rebuttal. May it please the court, Kyle Patrick was 17 years old when these offenses were committed. Now, the law is pretty clear that we can try juveniles as adults, but the law is equally clear that we cannot sentence juveniles as adult. Kyle, in this case, was bound over by a mandatory bind over and was tried as an adult, and the record is clear he was sentenced as an adult in this case. Yet everything about the Eighth Amendment jurisprudence says that he cannot be sentenced as an adult. The question here is whether a court can sentence any juvenile to any life offense without first doing what the Eighth Amendment commands. Now, the state in this case obviously has argued the horrendous facts of the case. We see that in all of the cases from Roper on down. It says that what we are doing is making policy arguments, and even talks about the original intent of the Eighth Amendment and the Ohio Constitution. All of us survey the case law, but what the state doesn't do, and what we think is the central premise here, is there a principled way to distinguish this life sentence, or indeed any life sentence for any juvenile who's tried as an adult? And no reason, is there a reason not to impose consider the Miller factors before imposing a sentence? We say that there is no principled reason, and that's why the Eighth Amendment commands what did not happen in this case. There's been some effort in the briefs to distinguish this case because it is not an LWOP case. It is not a life without parole case. The Amici, the appellants Amici, the juvenile leagues, cite some of the statutes from the Department of Rehabilitation and Corrections, talking about whether it's likely that a juvenile would get parole even if there's a possibility of parole. But The point for this appeal is that from the vantage of 2017, when this sentence was imposed, or from the vantage point of today in 2020, that this is a sentence that legally could have Kyle Patrick leaving the institution in a pine box. There is simply no way to determine. And so in that respect, yes, sir.
Let me ask you this. Is it your position that the sentencing record is just too void to suggest that the trial court judge in any way considered the youth of the defendant in this case? Do you concede that are there any facts that had the trial court judge placed them on the record that would support the more severe sentence that was handed out in this case? We're talking about, in this case, they're all life sentences, right? We're talking about when the defendant would first arrive at the parole board for consideration for release. So even the plea bargain that the state offered originally, he would have hit the parole board at 16 years. Okay, so the government and ODRC always retains the right, if they think he's a public safety risk, to keep him in prison for the rest of his life on all of these sentences. So my question is, are you saying that there is absolutely no facts that this trial court judge could have laid out for a reviewing court and to justify the more severe sentence in this case?
I hope I'm answering your question. There is the possibility of a more severe sentence than the minimum sentence, but the record in this case does not disclose that. So to answer your question, Justice Donnelly, about are there facts, there may have been facts one way or the other. All those things, we talk, all of us in our briefs, we use the shorthand term youth, but it isn't just the question of age, because of course his age was brought up. What wasn't brought up are all the things that Miller and the other cases say go with age: the impetuousness, the reckless behavior, the peer pressure. None of those things are before the trial court, so the trial court could not have considered them. And I think that one of the biggest things that indicates why that's true, this trial ended with a verdict on 4:30 in the afternoon on a Friday, and this appellant was sentenced on Monday morning at 9 a.m. without a pre-sentence investigation. So there just aren't those things in the record for the judge to have considered.
So can you address the argument raised by the state of Ohio that we should IA this case because there's a threshold jurisdictional issue that no one's addressed?
I can, and the first thing I guess I would say is waiver applies. There's case law from this court that waiver applies.
If we don't have jurisdiction, you can't waive that, can we?
Well, as I understand the state's argument, there's no jurisdiction because this sentence is not reviewable. And what I'm saying is that this sentence, that argument was not made in the Court of Appeals below, so the argument can't be asserted here as a basis not to review the sentence. So I would say that first of all. Secondly, I would say that.
Well, but again, that's a question. That would be a question of whether or not that statute goes to the subject matter jurisdiction of the court. If it goes to subject matter jurisdiction of the court, the state could waive it any time. We really haven't had any briefing or discussion of that.
That's true. There hasn't been any briefing, and the state does cite a case where the court on its own decides to take notice of an issue that wasn't raised in the Court of Appeals. I would stick by my waiver argument, but in addition to that, I would say that the statute that the state is citing plainly is not an apposite for a couple of reasons. First of all, the statute itself by its own terms says that a sentence for aggravated murder is not reviewable under this section. And I understand and respect what this court and the other courts have had to say. I have to disagree with that, that it's not with the conclusion that it's not reviewable at all. It simply says specifically it's not reviewable under this section. If you think about the logical corollary of that, any aggravated murder sentence in this state that wasn't a capital sentence would be precluded from review if you read the statute as the state wants you to read it. Lastly, I would also say about that, Justice DeWine, that we're not directly challenging the sentence, because going back to what Justice Donnelly asked, we don't really have the information to be able to make that intelligent challenge, much like the situation in State v. Long. This is simply a situation where the record isn't there, where the record doesn't indicate whether or not youth and all of those things that Miller says are attendant to it were even considered. I would submit this case is a little bit worse than Long, because in Long, at the time the trial judge considered sentence, Miller had not been decided. Here, Miller had been decided several years before the sentencing, in this case in 2017, which to me highlights the error of simply not considering those Miller factors.
Also, I want to address your statements that age just wasn't considered at all. I mean, don't we have some evidence in the record? For example, his mother testified and talked about, you know, this was just a matter of him being young and following the wrong crowd. We even had the prosecutor that saying that we need to do something different here because of his age. You know, don't we at least have some indication that the judge had all of those factors in front of it at the time?
Well, Your Honor, you have some indication in the sense that, just like in Long, where the judge, I think, sat through a much longer trial. If I recall, that was about a 4-week trial. This was just a several-day trial. And so the argument by the state was, well, the judge knew the age of the defendant. And sure, the judge here knew the age of the defendant. And yes, his mother made some comments about it. But that is an entirely different situation from making a full presentation, which I argue that defense counsel should have done, and the trial court should frankly have demanded under Miller to look into these matters a little more deeply rather than making that.
Even though here we had defense counsel talking about his youth, we had the prosecutor talking about his youth. So what kind of a hearing would you expect?
Well, I might expect a more detailed hearing on, we don't know if the mother made reference to drugs. You know, the state's position was that this was a robbery gone bad. The mother's position, and to the extent that Kyle Patrick revealed anything through his lawyer, was this was a drug deal. So, and the mother talked about how bad drugs were. We don't know anything about the appellant's history. We don't know anything about his family, one of the things that Miller says we should take into consideration. We know from the record that these 3 kids who he was with were all older than him. We don't really know anything about the peer pressure. And those are the things that Miller suggests should be addressed. And if I may, just to go back and answer the other part of your question about
Counsel,
the state.
Before you leave that part of the question, are you suggesting that in these type of cases, there has to be expert opinion?
I'm not, Chief Justice.
Okay, what are you saying? What could be the source of this information that you just outlined?
Well, for example, in Long, there were sentencing memoranda. Now, the opinion doesn't indicate whether there were things attached to it, but let's go back to this issue that I was talking about, Mr. Patrick's drug usage. Certainly, you could get, as would be done with a pre-sentence investigation, you could get those sort of records. You wouldn't necessarily need a psychologist to come in, but you could have parents and family members come in, school teachers come in to talk about peer pressure, that sort of thing. A fuller sentencing hearing then certainly was done here to address those Miller factors. And to go back to what Justice French asked you, talking about the state-raised age, the state raised it in sort of a left-handed fashion. They cited this court's decision in the Brandon Moore case and basically said, Judge, we really want you to give this guy life without parole. But since the Supreme Court said in the Brandon Moore case that you have to give him, and I think her words from the transcript were, some shot at parole somewhere out there, then we're asking you to do the next tick down, which in this case was 30 to life, or with the gun spec, 33 to life. And our position is that you don't circumvent the 8th Amendment and everything that Roper and Miller and Graham and Brandon Moore, all those cases say have to be done with the 8th Amendment. You don't circumvent that simply by ticking it down one sentence.
Let me ask you about Miller. You keep citing Miller, but wasn't really the thrust of Miller that the problem in Miller was the mandatory nature of the sentence precluded the judge from considering age at all. Whereas here, we don't have that problem. This doesn't seem to be like Miller at all.
I would agree with you and not agree with you. I would certainly agree with you that Miller did involve a mandatory life sentence, and that was one of the problems that the court had with it. But Justice Kagan talked about the fact that nothing that the court had said up to the point in time in Miller was crime specific. And if you look at everything the court has said, going back from Thompson, when they said you can't execute 16-year-olds, through Roper, through Graham, through Miller, everything the court has said is juveniles are different. They have a lesser sense of moral culpability. We have to take these into account. And so we submit that this case is the next logical step. Certainly Miller talked about a mandatory life sentence, but here the judge still had to choose from 4 very different options. And we concede, by the way, that life without parole is theoretically one of the things that he still could impose. The state asked him not to do that, but the prior decision of this court in Long, I think, says that's not off the table. The point of the diatribe here is that the judge didn't have the information necessary to make a meaningful choice between one of those options that the statute gave him upon the return of the verdict. So it is our position, and we know what all those factors are, and they all were not considered here and could have been considered. It's our position the 8th Amendment doesn't stop when it comes to juveniles at the death penalty, and it doesn't stop at life without parole. And so I'm going to reserve, if I may, unless there are other questions, the balance of my time for rebuttal.
Thank you.
Thank you.
Mr. Rivera.
Chief Justice O'Connor, may it please the court. Ralph Rivera on behalf of the state of Ohio and Mahoning County Prosecutor's Office. I will be splitting my time with Diane Bray from the Attorney General's Office. Good morning. As Mr. Uhas pointed out, the issue in this case is specifically whether the 8th Amendment requires a formal consideration of a use, of an offender's youth if they are sentenced to a life sentence with parole eligibility. And the key factor being formal consideration when the offender has the possibility for parole. Montgomery versus Louisiana clearly answered that question. The 8th Amendment does not require any formal consideration of an offender's youth if the trial court imposes a life sentence that carries with it the possibility for parole. Montgomery clearly stated that even when there is a Miller violation, the remedy for a Miller violation is not a sentencing hearing at all. It is simply the parole eligibility. If this was a case where there was a Miller violation, where there was a life without parole and there was no consideration whatsoever, the 8th Amendment does not even require a new sentencing hearing. The only thing that the 8th Amendment requires is the parole eligibility. The answer stops there.
So let me ask you this. Prior to this case going to trial, there was a plea bargain, right?
That's correct.
And the state had a command of all the facts that they eventually proved at the trial, probably more of a command than the trial court judge. Would you agree with that?
Yes.
Okay, so the state was okay with, in that plea bargain, the defendant hitting the parole board, receiving a life sentence, but hitting the parole board at 16 years. And the defendant withdrew from that plea agreement and opted to go to trial. What did the state learn? What new facts that weren't available to them that caused them, after the fact that you convicted him of what you charged him with, to advocate for the most severe time to go before the parole board, and that is 30 to life, rather than 25 or 20 to life? What changed that advocacy?
Well, the simple answer to that is the cold-blooded nature of this murder. The facts as they came out in trial, and they're not necessary, you don't know every single detail, but the key details that were learned through the trial testimony was the fact that upon the victim going upstairs, he was shot immediately upon going upstairs. As his friend testified, there was no struggle upstairs to suggest less of a cold-blooded nature. The victim walked upstairs. There was a discussion about a PlayStation and a laptop. He was murdered immediately upon walking up the steps. Now, that is just one of the details that was learned. However,
he wasn't aware of that prior to proceeding to trial?
Well, you're aware of certain facts, but how they specifically come out in trial are completely different to the facts that you may know of certain facts, but you don't know exactly how they're going to come out in trial.
Okay. One more question, one more follow-up question. At a sentencing hearing, trial court judges are guided by the overall principles of our sentencing as embodied in 29, 29, 11, 12, and that is to punish the offender, protect the community, rehabilitate the defender if that's even possible, and use the least amount of resources possible to achieve these principles. Don't you think it's incumbent upon trial court judges, if they're going to go, as they did in this case, the most severe and use the most amount of resources to articulate more reasons why? For instance, they could get a pre-sentence report. They could say this person has been diagnosed with a behavioral disorder that's not going to be subject to rehabilitation. That's going to present safety issues in the future. Then an appellate court could review that decision and possibly agree with the more severe sentence. Wouldn't that be a better situation than we have?
To answer your question specifically, the trial court did not impose the most severe sanction. Life without parole was a possibility and would be the most severe sanction. And
but you told them not to do that for legal reasons, right? Or your office did.
Well, yeah, I was, just to kind of clarify if there's any confusion, I was not trial counsel. I was not involved in any type of pre-trial discussions involving this case. But yes, the state did ask for a 30 to life a sentence. I'm not in the mind of that specific prosecutor to tell you exactly why that was asked for. But had the trial court given the life without parole, then the trial court would be required under law to then state those specific considerations on the record. However, nothing in the Eighth Amendment, nothing in the Eighth Amendment nor the revised code requires the trial court to put any of those factors on the record. Now, of course, as the court stated in Long, yes, the court is guided by 29-29-11 and 29-29-12 in every felony sentencing hearing. They were applicable here. The state is not saying that the trial court should ignore any considerations regarding youth or any specific factors that a defense counsel or the state advocates at a sentencing hearing. Our position is that the Eighth Amendment does not require formal findings on the record as the court held in Long. This court in Long and the United States Supreme Court in Montgomery clearly drew that line at life without parole. Anything below life without parole satisfies the Eighth Amendment. And again, every Ohio appellate court that has dealt with this issue has followed that line of thinking. If the sentencing court is imposing anything less than life without parole, those formal considerations are not required to be placed on the record. Of course, again, those considerations, and from the case law through the appellate courts and this court, the considerations under 29-29-11 and 29-29-12, which include an offender's youth, are presumed from the record. A silent record presumes that those considerations were considered, and the trial court considered all of the arguments that the state made, all of the arguments that the defendant made. In this case, the defense counsel did put on the record, made arguments regarding his youth, his immaturity. Certainly, as counsel spoke, his mother spoke to his immaturity. spoke to that he was just a follower, he wasn't a leader. The trial court is presumed to have taken those things into consideration. And kind of just to point to the court's judgment entry, the trial court's judgment entry clearly states that he did take into consideration both 292911 and 292912. Kind of touching upon the overall theme of Graham and Miller and Moore and Long those were cases where the juvenile offender had no possibility of parole. They had no possibility of release. The concerns were when you incarcerate a juvenile without the possibility of parole, you're assuming that rehabilitation is impossible. You're assuming that that specific offender does not have the ability to change. As the court talks about, life without parole is reserved for those rare juvenile offenders that are completely irredeemable. Those issues are concerns. Those concerns are not present in this case. They're not present because Mr. Patrick, regardless if it's after 20 or 25 or 30, he still has the possibility of parole. And Montgomery made clear, once a juvenile offender is eligible for parole, the Eighth Amendment is satisfied. I would like to reserve, if I could, the remaining time for Ms. Bray.
Counsel.
Thank you. Chief Justice, may it please the court. I'd like to begin by addressing one of the points that opposing counsel made at the beginning of his argument about saying that there's no principled way to distinguish between this life sentence and the other life sentences that were a possibility here. And we would beg to differ. We'd say this distinguishing feature is the possibility of parole, which Mr. Patrick got. As my co-counsel has pointed out, the U.S. Supreme Court in the Montgomery case said, in fact, that the remedy for a Miller violation was consideration for parole at some point. And if it is the remedy for a Miller violation, then it stands to reason that a sentence that provides the possibility for parole consideration is not a Miller violation to begin with. In fact, the state's rule provides a more clear rule here for the court, and that is that if a juvenile sentence provides for the possibility of parole well within the juvenile's lifetime, that satisfies the Eighth Amendment and Article 1, Section 9 of the Ohio Constitution.
Counsel, the way I understand the appellant's argument, it's not so much whether this was an appropriate, whether in the abstract, this sentence was available to the court to impose here. It's the fact that there is no bases that can be identified that the judge considered when imposing this sentence with this length of time before the parole board. So it's not an argument whether under no circumstances can this sentence with these configurations be imposed. It's just that the court needs to do more.
Your Honor, I think Mr. Rivera said it well when he said that, as this court said in Long and some other cases, that you look at the age and age-related factors as a constitutional matter when there's a life without parole sentence for the juvenile. And here it was one of the discretionary sentences that was a lesser option than that. And so that those Eighth Amendment requirements don't apply here.
So you're saying that the court does not have to take into consideration youth or any of the other ramifications of youth?
Certainly not any findings on the record. And in fact, in this case, as Mr. Rivera pointed out, there was consideration of that, given that both counsel at sentencing presented argument on the age and age-related factors issue. in the sense that they talked about it, and the mother talked specifically about her thoughts about it and the maturity in her view of her son. So this was before the court. The court recited in its sentencing entry that he had considered the factors that he needed to consider. So this is simply, it's not a case where no consideration was given to it, but as a constitutional matter, that heightened requirement applies for life without parole, but we would say does not apply to these lower sentences. And it makes sense if you think about it. I mean, what would be the distinguishing feature to say that, well, okay, if the line isn't life without parole, then is it the 30-year life with 30 years? Is it life with 25 years or 20? Is it a 20-year sentence? Is it a 15-year sentence? I mean, we don't know. There's no objective, principled way to draw that line other than the line that is already drawn for us with the Miller and Montgomery cases, which is at life without parole.
So are you saying that when a youth is before the court on a serious felony such as this, there is no requirement to employ the Miller factors, and youth in and of itself is not sufficient to trigger a different scrutiny than you would in adult sentencing?
Well, it's certainly one of the factors that can be considered, as this court said very clearly in Long, that it's age and age-related factors. It's one other consideration in applying and choosing the right sentence as a matter of the sentencing court's discretion. But Long also said that it doesn't mean that that factor has to be given a particular weight as part of the sentencing. It does not, in other words, dictate the result. And the fact that
I don't think the opposing counsel is saying it dictates the result. He said this may be an appropriate sentence. They're not taking the sentence off the table. He's just saying, you know, that the sufficiency of the sentence or the propriety of the sentence would have been clear had the judge articulated his considerations here.
Your Honor, I would respectfully disagree in that the judge, we presume that he considered what was presented to him, and it certainly was presented to him. And the Miller and Long and Montgomery cases say that if you have a Miller violation, parole is the remedy, and parole was part of this sentence from the day it was imposed. And so therefore it satisfies any constitutional concerns. And moreover, in terms of the state constitutional provision, Article 1, Section 9, that was not argued specifically in the brief and was abandoned here. So to the extent there's any separate consideration, there's no need for the court to do that in this case. For all these reasons, we respectfully ask the court to affirm or to improv this case. Thank you.
Thank you. Counsel?
May it please the court. So if I understand the state's argument here, the Eighth Amendment doesn't apply because a judge has to predetermine what sentence he's going to impose. It's only if he decides that he's going to impose a life sentence without parole before the sentencing hearing starts that he doesn't have to take into consideration all of the Miller factors. If he decides that it's some sentence that's authorized by law but less than LWOP, then he doesn't have to consider any of the factors. I would say a couple things about the state's argument about Montgomery. First of all, the case is mostly about retroactivity, but secondly, to this extent that the case is about parole being a remedy for a Miller violation. Indeed, it is a remedy for a Miller violation because Miller involved a mandatory LWOP sentence. So of course, parole is the remedy. What we're saying here is just what I said a moment ago, that it makes no sense under the Eighth Amendment not to consider these factors. These factors are the things that the courts have said go into the less culpability and the redeemability, so it should factor into which of the 4 sentences the judge chose. And I see I'm out of time, and I think the court.
Counsel, I have a question. You started off with your pine box argument. I want to follow up a little bit. Are you saying the Miller factors have to be considered every time a youth is sentenced on any basis?
No, I'm saying that the Miller factors have to be considered. I think the court's already said that's not the case, that felony sentences are okay. I'm saying that the Miller factors have to be considered when it's a life sentence. That's our proposition in this court, and that's all we're urging this court to find.
Thank you.
All right, thank you. Thank you very much. We'll take the matter under advisement, and you'll be notified of our decision. Our next case is 2019-1742, Disciplinary Counsel versus James Lewis Reinheimer. For the respondent, Mr. Coghlan.
Thank you, Your Honor. Chief Justice O'Connor, may it please the court. I'm John Coghlan on behalf of the respondent. I'd like to reserve 5 minutes for rebuttal. I'd like to address primarily one issue and perhaps a second if I have time. My primary issue I'd like the court to consider is the due process concerns that we have expressed in our brief. This is a rather unique set of circumstances for a disciplinary case. After successfully defending against the 3 charge rule violations, respondent was found guilty of violating 2 uncharged violations that were first mentioned after the close of the evidence. According to the board report, respondent violated those 2 uncharged violations when he failed to adequately discuss with his client his strategy concerning the motion for summary judgment. But respondent was never on notice that that's what he was having to face as a charge for the communication, as a basis for the communication charge in the case at all. Relator's allegation was that his failure to respond to the motion for summary judgment was itself misconduct, that was evidence of the violation of competency rule 1.1, that was evidence of the diligence rule 1.3. They never accepted that as a viable theory or strategy that he had throughout his representation.
Coghlan, if those charges had been alleged at the beginning of the case, what would your client have done differently? How was he prejudiced, in other words?
Appreciate the question. We would have had a completely different defense in this matter. First, let me explain what we did do, briefly explain what we did do was firmly defend against the theory that he acted negligently and incompetently. What we would have done, had the case been as it turned out to have, as the board found it, the only issue had been that he failed to adequately communicate his strategy with his client. The only issue then would have been credibility. At the hearing, when this issue was touched upon, the grievant, his client, testified he did not explain that to her. He testified that he did explain that to her. Instead of affirmatively establishing all the evidence that we did that he had a viable theory, that he properly represented her through her testimony, through the judge's testimony, through opposing counsel's testimony, we would have been focusing on her credibility in this case. We took her deposition in the disciplinary case. She had been deposed in the defamation case. There were a number of facets in her testimony that could have been utilized to try and have the board and the court properly evaluate her credibility. We never went after that because we were focused on defending against competence and diligence. And we did so. I'm sorry.
Excuse me. When he made the decision not to respond to the motion for summary judgment, he was under the impression that the subsequent damage hearing would result in nominal damages. Is that correct?
Correct. That was his understanding. Correct.
What did he base that on? Just his, or did he have a discussion in chambers with the judge and the judge told him that's what was going to happen?
Correct. I had both the judge testify and opposing counsel testify. They both confirmed that was the judge's take on the case, nominal damages. And based on that, he chose, rather than subject his client to a jury trial where who knows what would happen, that the better option would be to proceed with not opposing the motion for summary judgment. Both the judge and opposing counsel were aware that that's what he was doing.
And the judge had already represented that that's what he was going to do.
I can't tell you that he said affirmatively, I will only do X, but he made it very clear to the lawyers that he thought there were no damages.
Okay. Thank you.
Yeah. So that really is the gist of the case. And we're concerned that we were under the clear impression what the charges were, both factually and legally. That's what we faced. That's what we successfully defended against. It was only after the close of the evidence that these other charges, these other rule violations were brought up. I'm going to reserve.
Counsel, let me ask you a question. She was also found to owe legal fees, correct?
It is true there was evidence that she had not paid all the legal fees. That's correct.
Well, no, what I mean is that the client was, the summary judgment was granted and then legal fees were awarded against her, correct?
Correct.
And how much was the legal fees?
Legal fees were, I believe, $2,000. I agree completely that that happened, no question. And I think both sides were surprised. I asked both my client and opposing counsel, and they acknowledged that at the damages hearing, legal fees were never raised. Opposing counsel even asked for legal fees to be included. So, but yes, that was imposed.
Well, that wasn't, unheard of or out of the realm of the usual, the ordinary, for the granting of legal fees under these circumstances, right?
Absolutely correct. That was part of a risk that he took. And I understand that this was a strategy. It had certain risks, but the panel found that they had no concerns with this selected strategy. Was it the best strategy? I don't know. I'm not here to argue that. They were certainly up against a plaintiff who was litigating this case for personal reasons. He refused to make a demand. He refused to do anything except request a jury trial where it was perceived by my client and his client, the grievant, that he wished to try to embarrass her. That was his focus, to try to embarrass her at a jury trial. She did not want to do that. My client was well aware of it. He was seeking ways to avoid that. They had discussions about a consent judgment entry, and they got close, but that never happened. Even in the board report, they acknowledged that he made several efforts to resolve this and ultimately chose this method as the only one he felt was viable. If I might, I'll reserve my time for rebuttal. Thank you.
Counsel.
Chief Justice O'Connor, and may it please the court. My name is Audrey Varwig, and I represent the Relator Disciplinary Council. There are 3 reasons why the court should overrule the respondent's objections and adopt the findings, conclusions, and recommendation of the board. First, respondent's due process claim is unsubstantiated. This is for the first time today, we are hearing how the respondent claims that he was not afforded a meaningful opportunity to present evidence in his defense. The panel gave him 2 weeks to brief this issue, and there was no explanation of how he was deprived of engaging in discovery or in admitting evidence during the hearing of this matter. This issue involves only 2 people, the respondent and his client. He deposed her, as he said, prior to the hearing, and his written discovery was directed at all communications between him and his client. There was no writing memorializing any acknowledgement or understanding by his client of the strategy to allow the motion for summary judgment to go unopposed. So there was no documentary evidence that he was not permitted to introduce. The respondent has not substantiated his due process claim, and his objection can be overruled for that purpose. The second reason why the court can overrule the respondent's due process objection is because due process requirements were not met in this case. Due process requirements in a disciplinary matter are not the same as the requirements in a criminal matter. Disciplinary matters are instituted to protect the public, and due process requirements are met as long as the respondent had notice of the misconduct and he was afforded an opportunity to defend himself. In this case, relator charged respondent with failure to communicate from the beginning. The allegations put respondent on notice that his failure to communicate with his client was at issue. And he knew it was at issue because in his answer, he claimed that he communicated with his client, and he also claimed that he communicated his strategy to allow the summary judgment to be entered against her. His failure to communicate was also fully tried during the hearing. Respondent concedes that the panel questioned him about his communication with his client and specifically his strategy during the hearing. Relator also questioned regarding the strategy, and there was no objection. The case was fully tried, and then after the hearing, it was briefed. The board found one violation of Rule 1.4, and it was based upon Division A1 and Division B. The board stated that these divisions are so similar in nature and character to the originally charged misconduct that it did not substantially change the originally charged misconduct.
Counsel, was the credibility of the client discussed, delved into the subject of the trial?
To the extent that she testified, Your Honor, and was cross-examined, absolutely. Her credibility was at issue. It was before the board, and they made an assessment of her credibility.
Did she testify in a way that would have addressed the concerns of Mr. Reinheimer? In other words, she testified that she was not aware that this was the strategies, that she's had numerous phone conversations with him, and this was never explained to her what this strategy was going to be. Is that in a nutshell?
Yes, Your Honor.
All right. And then was that on cross-examination challenged, that her memory was accurate, that she was telling the truth, that what about this, that, and the other, to try and discredit her?
Yes, she was challenged even about a consent judgment entry that was discussed at one point. So her credibility was fully examined during the hearing. So the respondent was on notice regarding his failure to communicate, and he was afforded a reasonable opportunity to defend himself. So the court should overrule his due process objection. The third reason why the court should overrule the respondent's objections is because the record supports the violation. In this case, as I stated, the board found a violation of Rule 1.4 based upon Division A1 and Division B. It is undisputed that the respondent failed to notify his client that a motion for summary judgment had been filed against her. She testified that she did not even know what a motion for summary judgment was. And even after it was issued against her, she still thought she was going to have a trial. Her expectation for the representation was that she was going to defend against the defamation allegations that were filed against her. She refused to offer even $1 to settle the case. And when she received a $2,600 judgment against her in the mail, she was upset and she wanted to appeal. Her testimony showed that she was not aware and she did not understand the strategy to allow the motion for summary judgment to go unopposed. And she did not know that the goal was to put an end to the case rather than to vindicate her actions.
Well, one of the questions, whether she was fully aware of the strategy, it's one thing to be aware of a strategy, but to be informed of what the potential consequences will be of that strategy. Was there questioning about that to her? You said that she was upset for receiving a bill of $2,600. So I'm presuming her testimony was, I never, ever would have thought that that would have happened. That was never communicated. I never would agree to it.
Correct, it was. And in fact, she stated that her discussions with the respondent were of the nature where he told her that She simply didn't need to worry about the case that she was never going to pay any money towards him or pay any money at all. What she didn't understand was that there was going to be a judgment against her in the respondent's plan that he expected she would never pay.
Because she was judgment proof or what?
That was his testimony, yes.
Okay.
So inherent in the board's finding that the respondent failed to obtain his client's informed consent to allow the motion for summary judgment to go unopposed is the board's finding that the client was a credible witness. The court defers to the board's credibility determinations and factual findings unless the record weighs heavily against them. In this case, it does not. Based upon the testimony that I have shared with you, it is clear that the board found the client to be credible and that she was not aware of the strategy to allow the motion for summary judgment to go unopposed. She didn't fully understand it. The respondent claims that there were some inconsistencies in her testimony. However, the court has recognized that inconsistencies in the evidence do not necessarily warrant disregarding the board's findings. In this case, any inconsistencies in her testimony were as a result of her lack of understanding caused by the respondent's failure to communicate with her. Therefore, the court should not disregard the panel's findings in this case. The respondent's second objection should be overruled. The respondent's failure to communicate in this case was alleged, it was tried, and then it was briefed. The record supports the violation. Relator asked that this court protect the public by overruling the respondent's objections and adopting the findings, conclusions, and recommendation of the board. Thank you.
Thank you. Counsel? You're muted, Mr. Coughlin.
Thank you. Sorry about that. I think that the Chief Justice's question goes to a big part of this issue, and that is what was asked of the grievant, the witness, as to what was discussed with her. Was it properly vetted in the hearing as to what she knew about his strategy and what he did or didn't explain to her? Relator asked one question about his strategy of the grievant. Did he explain his strategy? She never said, did he discuss with you motion for summary judgment? None of that came up from Relator's questions. That came up with a few of the questions by the panel members. So my problem is not as to was there sufficient evidence for the violation they ultimately found, although I have concerns about that. My problem is we didn't know we needed to address that. We didn't know we needed to go and approach the whole communication issue as about whether he discussed his strategy. Their whole theory of the case was his failure to respond to the motion for summary judgment was evidence of misconduct itself, not that it was a viable strategy and that she wasn't properly advised of that viable strategy. If you look at the complaint, there are three aspects that they allege supported the 1.4A3, which is failing to reasonably inform your client about the status of the matter. That's what we were defending against. They claimed that he failed to properly notify her of the filing of the motion for summary judgment. Yes, we admitted that because he had discussed it with her in advance. She already knew that was coming, so he did not feel he needed to send it to her. Should he have? Of course. We're not here talking about best practice, though. Then the failure to notify her of the damages hearing. She testified she knew about the damages hearing. We established, again, affirmative that the clerk's office sends out notices of all the proceedings to the parties in addition to counsel in advance, and she got that. Finally, failure to notify his client of the hearing on the damages after remand. There was no hearing on damages after remand. So we successfully defended against the communication charge that was brought. That's what we were faced with. That's what we established. And it was not viable. Now, we've just heard that apparently these are synonymous. A 1.4A1 is the same as a 1.4A3. we completely disagree. They are different provisions. We would have defended this case differently had we known what we were facing. Not once did they ever say, we established it was a viable strategy. We had to defend against the diligence and incompetence. But not once did the relator say, oh, but you didn't properly explain it to her. I agree, there's some evidence of that in this record. But our problem was we weren't able to properly defend against that in preparation for the hearing and during the hearing.
Mr. Copeland, I think your friend on the other side says that you were given 2 weeks to brief the issue and didn't take advantage of that. How do you respond to that?
Well, what I agree that I didn't put in my brief before this court how we would have defended differently. I agree. But that doesn't mean we wouldn't have defended it differently. You look at the record, you could see what we did do, because what we were faced with what we addressed. We were faced with
maybe I've misunderstood. Was there an opportunity after the hearing for you to brief the issue?
We were asked to brief the applicability of a violation for 1.4A3, whether or not the relator could make its motion to amend, and then the applicability of the 2 uncharged violations.
And did you take advantage of that briefing?
I did.
Okay.
I didn't fail to brief that.
Gotcha.
What I didn't do was argue vociferously that we would have had a different defense. Their theory is, well, you would have had the same defense, so it doesn't matter. That's not true.
All right. Thank you. I appreciate that clarification.
Sure. One other thing, we've been, I think relator and I would obviously disagree, but there's findings that there were problems with the grievance credibility by the panel. It's implicit in the report. Their report was he needed to properly, thoroughly, and reasonably explain his strategy to her, and he didn't do that. That's their finding. That was based on questions that were asked of him at the very end of the hearing when he was being examined by the panel. And I agree, there are questions there. We were, at that point, the hearing is virtually over. But regardless, the point is, she had said it never happened. The panel found he didn't do it properly and thoroughly. In other words, they credited him with talking to her about his strategy. Their concern was he didn't do it effectively, he didn't do it thoroughly. That refutes her credibility to some extent, because she said it never happened. So I just bring that to your attention that we would have had more to work with. We would have not. We would have definitely developed more about credibility, because that would have been the only issue. So my concern is that we weren't able to properly defend against what we were ultimately held to be responsible for. I would ask the court to consider the Cincinnati Bar versus Wiest case. I think that's very close to what we have here. In Wiest, there was a 1.6 violation charged that prior to the hearing, the relator, Cincinnati Bar, claimed he violated that because he used client confidential information to make a stock trade. At the hearing, they switched their theory, their factual predicate, and went with the theory that he disclosed client confidential information to the SEC. The panel said that we can't find a 1.6 based on that because you didn't tell him that was your basis before the hearing. He was also charged with an 8.4B, illegal act adversely reflecting on honesty and truthfulness. The panel found that violation on the same facts. That is, that he disclosed confidential information to the SEC. This court said, no, if it's a due process problem that you didn't tell him about those facts as a support for the 1.6 confidentiality violation, it's the same problem as to the 8.4B. That's what we have here. They switched their factual theory. We had no idea until after the case that the theory was he didn't properly communicate his strategy. In addition, as an aggravating factor in this case, they switched the violations. So I think this is even worse example of a due process problem. Finally, I would like the court to consider what this court has cited several times is language from the Ruffalo case. It shows up in the Wiest case, it shows up in the Sigaloff case, and that is as follows. The charge must be known before the proceedings commence. They become a trap when, after they are underway, the charges are amended on the basis of the testimony of the accused. I submit that's what we have been subjected to here, not by any ill will, but that's what's happened here. And these are rule violations we didn't know about. This is a factual predicate that the relator specifically did not believe in until after the evidence was closed. We would ask the court to dismiss these charges. Thank you.
Thank you. Thank you. We'll take the matter under advisement and you'll be notified of our decision. Marshall, will you adjourn court?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.